How do I co-parent with someone who refuses to communicate? So this is the thing. Usually in judgments, it states a certain time limitation. And if yours doesn't, you need to really look into it with your attorney. Like parent A has to give parent B notification of certain decisions. And parent B usually has a number of days times whatever to respond to parent A's notification with an agreement or a disagreement. There has to be an end goal, right? You cannot unreasonably withhold consent. It's going to affect your kids. If someone does not communicate, at some point, decisions have to be made. A lot of the allocation judgments that I've personally worked on, certain things are already set in stone. So even if there's no communication, things are going to happen in a certain way. For instance, the school is usually designated pursuant to one of the parents' addresses. You don't need to communicate with the other party if it already states where the kid's going to go to school. The allocation judgment usually also designates if the child is going to go to the same doctors and what's going to happen if the doctor is no longer affiliated with the insurance or there's going to be a change in doctors. Sometimes if there's co-parenting agreements, right, provisions that you have to co-parent, it'll say like, okay, if we're going to change doctors, parent A can make that final decision, or there has to be an agreement. But if there's no agreement, parent B can make the decision. Or if there's no agreement, then they have to go to mediation. At some point, there has to be a decision made. It cannot just be floating in the air. And if you cannot communicate with the other parent at all, that needs to be brought up before an allocation judgment is entered. The judge needs to know that there's an inability to communicate. The judge needs to know that you have tried to communicate, and the judge needs to put in place a provision of what happens when the other person doesn't communicate. You do not want to keep coming back to court over these things. It is nonsensical, it's unfeasible, and it doesn't make sense. There has to be an end game here. And I think we've all seen cases where one party is very communicative and the other party just goes MIA, and they think that by doing that, they're going to get away with not having to contribute with out-of-pocket expenses, not having to take responsibility of the decisions being made on behalf of the child. They just don't want to take accountability for anything, but then they're the same parent that cries when, the parent that is making the decisions is forced to make decisions because they never heard back from the other parent, and it's frustrating. So you need to make sure that in your allocation judgment, it outlines what happens if you don't hear back from the other parent, because you don't want to go back to court.